Hi, I am Michele from Allenot Law Office Professional Corporation in Cornwall, and I wanted to talk to you about a recent case that the Supreme Court of Canada has affirmed. It's a tax case which is super not fun for people to read. I did post about it on social media, but I thought I would do this little video to explain exactly why this decision is important. So the case is about a GST rebate on a new home purchase and what's required for an owner to actually qualify for that rebate. So when you buy a new home, the builder typically assumes that you're eligible for the new home rebate, and they build that into the purchase price. So there's various credits, and you assign the rebate to the builder, and you get the full benefit of the rebate without having to do the paperwork, without having to pay the HST up front and then request it back from the government. So that's how most new home purchases go. There are requirements to being eligible for this rebate. Particularly, you have to be buying the home as your principal residence, and you need to live there after closing. There are other rebates available for people that are buying new homes that they're going to be renting out, but this isn't the rebate that we're talking about here. So in this case, it's called Chima versus the Queen. The homeowner couldn't qualify for the mortgage on him and his spouse couldn't qualify for it on their own. So a close friend signed the agreement, co-signed the mortgage, and then also was on title as an owner. Outside of all the registered documents, the three parties had an agreement between them that the friend who was the co-signer, he only owned a 1% interest in the property. It was just for the purposes of financing, that he didn't actually own it in his own right. It was in trust for his friend and his friend's spouse. And that's typically how we handle things. Usually the third person is a parent, but that's how they did it in this case, and that's how we've done it in several different home purchases. So what did the Supreme Court of Canada say? They didn't really say anything. They were just affirming another court's decision. But what their refusal to reconsider the matter means is that the law in Canada is, in order to qualify for this rebate, you need to live in the home as your primary residence, and you need to you need to live in it after closing, and it needs to be your primary residence. And that goes for all the parties on the agreement of purchase and sale and on the deed. So you can see this is a problem for people in the Chima situation. They can't qualify for financing on their own. They need someone else to assist them. You might have entered into an agreement with a builder assuming that you're eligible for the rebate, and then find out that you're not eligible when the mortgage financing works out. So this is potentially a big problem for builders and for home buyers. You'd have to renegotiate things or step away from the deal if you were no longer eligible for this rebate. So this is a good lesson in making sure you have proper professional legal advice, and also, you're dealing with your financing, you're probably, dealing with a realtor. You need professional advice when you're buying a home, and you also really should make any offer that you make on a home conditional upon having your proper financing in place, and don't waive that until you know for sure that you have the formal approval in hand from the bank that outlines exactly, what you're qualified for, and that they're going to fund a mortgage on this particular property. Thanks for listening to my boring topic on taxes. I hope this was helpful.